First of all, I like to express my gratitude to Professor for having an idea how to structure our panels and providing me with suggestions and guidelines for the questionnaires that were put forward to you and also forwarded to you. And also I would of course like to thank me, because in certain sense I was a host. I had like two pretty big and long weeks regarding organizing. Maybe my presentations a little suffered in terms of substantive content, but it's okay. So yes, my presentation will be in somehow natural continuation of what colleague Iveta started speaking, but also it will tackle some other issues that previous colleagues said. Of course, I would just start with emphasis that, as we all know, private international law rules are structured around the principle of mutual recognition and decisional harmony. That is, let's say, ratio legis of uniformity of rules of private international law, at least in European context. And those are necessarily connected with the principles of predictability, legal certainty, and also legitimate expectations of the party, because it's conceived that if we lack one of those elements, then the individual justice in particular cases can be compromised. And of course, as other instruments of private international law, the EU succession regulation introduced uniform rules in terms of applicable law and also jurisdiction. As already my colleague said, it was tailored around the last habitual residence of the deceased at the time of death as the primary and main connecting factor for both jurisdiction and applicable law. And it also follows Gleichlauf principles, or harmonization between the forum and use in any particular case. So it's visible that the intention of the legislator was that the court who has jurisdiction to apply, who have jurisdiction under the regulation should apply its own law. So that was the main idea. Colleague Alexander mentioned some exceptions that can be regarded as an exemption, for example, Article 10 and also Article 12, but they are, from my point of view, they're mainly constructed to deal with the situations that are closely connected to third states. So in that regard, they can also somehow, in particular cases, of course, depending on the constellation of facts or activities of the party, still preserve some underlying principles like unity of succession or Gleichlauf. So in that sense, I would not regard them as, we will see later on how Advocate General said that particular those articles are saying that succession regulations was intended to be split model friendly, and thereby we cannot regard particular bilateral agreements that employ different rules necessarily to be the ones who may impair proper functioning of internal markets. So that would be really interesting to embark later on. And of course, with regard with bilateral treaties, we are indebted to the joint group of University of Augsburg and Munich, because they commenced a really comprehensive and thorough analysis of the existing bilateral treaties in 2019 in collaboration with Professor Duta and Professor Wurmest, and they provided us with a really big and thorough country reports on bilateral treaties. Before that, we didn't have that complied at one place, and also they suffered a lot of problems with gathering all of these bilateral treaties. And as you can see here, most of them follow decision of succession either on jurisdiction level or on both jurisdiction and covenantal levels by usual employing locus rei situ for immovable estate and nationality or domicile of the deceased for the movable estate as connecting factors. And also, when it comes to conflict of law level, they provide also nationality as a general conflict of law rule, usually, whereas the question of choosing applicable law is not regulated at all in most of them. I mean, actually in all of them, as far as we researched. So, as you can see at the first glance, but of course, it's necessary to discuss whether these concepts are incompatible with rules of ECR in particular cases. They seem to completely differ from those delineated in ESR because, as you see, they are somehow constructed and based on, let's say, outdated private international law concepts that follow nationality principles, and we all know what is the idea behind that. So I will, of course, refer to it a little bit later. And moving on, it's really important to emphasize that these bilateral treaties, as colleague Iveta said, they supersede application of ECR when the scope of application of ESR and those treaties coincide. And this is completely in line with Article 351, paragraph 1, which allows which basically derogate primacy of EU law in terms in order to respect the international obligations of member states between them and third countries. But at the same time, this so-called compatibility clause is somehow modified by paragraph 2, which demands that if incompatibilities in particular case between treaties and EU law are found, they have to be eliminated, and also, if necessary, requires all member states to assist each other in fulfilling this objective. This is also stemming from the Article 4.2 of Treaty of European Union, so-called principles of sincere cooperation, and it's also, this article is also present in some other private international law instruments, explicitly, for example, in maintenance regulation, and also I think it was explicitly also in the regulation regarding enhanced cooperation in matrimonial property regimes, yeah. But also other private international law instruments mandate this such a rule. And of course, case law of the CGU was really extensive with regard to this matter. First, it was like basically the first precedent that introduced that line of reasoning was General Burgoan, Commission Italy. But in Cadi case, court was really explicit. He said that even though there are obligations of member states toward third states that have to be respected in accordance to Pacta sunt servanda, that EU law encompasses certain core constitutional principles which cannot be, which have to be protected in every particular case. So basically, in that sense, it's not that CGEU somehow tries to interpret bilateral agreements which are not part of acquis, let's say, and in all of these case law, it says that it doesn't have competence to interpret them, but it interprets their conformity with EU law, and that's a completely different level, because also CGEU is mandated with such an obligation according to the primary law, in particular Article 351.2. For example, also really interesting case law was Commission versus Germany from 2010, where court said that neither member states, neither EU can avoid conformity interpretation of their actions that stem from the international obligation towards their state, and especially in cases where a principle of equality or non-discrimination can be compromised. So that's like the threshold, the borderline where CGU has to step and provide some additional guidelines, and we will see how those questions can be solved institutionally by member states in CGU if we determine that there are some impairment with principles of internal market. But I will just shortly refer to that because my topic is slightly different. So here, as you can see, some theoretical framework that, as we all know, the proper functioning of internal market is inter alia dependent upon the creation of area of security or justice. And the main pillars of this area are free movement of people and mutual recognition of judgments as the main principles of EU law and consequently of private international law of European Union. And they are based on member states' mutual trust in each other's administration of justice and enforcement of the rule of law, which also stems from the principle of sincere cooperation between member states. So if we follow this normative argumentation, we can deduce that there are twofold obligations within the EU that stem from this article, paragraph 2. First one is bestowed on the member states bound by a bilateral treaty, and the other one on the member states not bound by a bilateral treaty. So in the first case, if there are impairment, member states can do several things. For example, they may decide to amend those treaties to comply with the obligation of Article 351, paragraph 2, but just, of course, in the scope of the part of the agreement that deals with succession matters, not the whole one. And also, there is Article, I think, 2258 of the TFU, which allows EU to commence so-called infringement procedure on the member states if they do not comply with the primary law. So this is also the case, but as we saw, for example, when the succession regulation was drafted, some member states which were bound by such treaties, they decided to amend them, and it was a good practice. But in some cases, it can be really tricky and problematic, but we will maybe come to that later. But, which is, now we are coming to the main point of my presentation and my research, is can there be a duty of the member state which are not bound by such treaty to nevertheless take in consideration such a treaty in order to comply with the Article 351.2 or the principle of sincere cooperation, because it's not just on the member state that are bound by such treaty. There is a duty for them to comply with the proper functioning of the internal market and those principles, but also on those member states that are not bound by said treaty, because that's a common approach of sincere cooperation of member states. They need to mutually act as one voice, let's say, in certain matters. So, particularly in cross-border succession cases that involve a third state and at least two member states, where one of them is bound by such bilateral treaty, might produce an outcome where accidental discrimination occur and contradictory judgments are passed by the virtue of the concurrent application of ERSR and bilateral treaty across member states. So, bearing in mind that, as I already told, this obligation also is bestowed on the member states that are not bound by such treaty, we can conclude, it's reasonable to conclude, that they nevertheless have to take into consideration those rules if they have a bearing on the case. And notion bearing on the case means that if rules of the foreign law which are not directly applicable but the lex fori nevertheless have effective, certain effect on the one particular aspect of the case, and therefore they may compromise the outcome of the case, which none of the countries involved in the case would not like to achieve if it would be just their internal case without the application of different conflict of law rules or substantive law rules. So, yes, the member state cannot, the conclusion is the member state cannot exclusively rely on the rules of ECR, but also have to consider the rules of bilateral treaties even when they're not being applied by their forum. So, legal obligation of member states, as I already told you, I will not try to repeat this too much. But we will also, besides normative argumentation, we can also have some, let's say, theoretical argumentation for that. As you all know, the opinion 103 on Lugano Convention, which is important for us in many aspects, but not just this one. We also had that before. I researched, we had that before on the Green Paper on the Rome Convention, where it's explicitly said that the rules of private international law can they don't have any consequence on the principles of internal market, which are by therefore superior to the rules of the private international law. And here in paragraph 128, it's said that consistent application of EU legal acts is mandatory in order to, of course, have mutual recognition of judgments, which are based, of course, again on the mutual trust. And as we know, the mutual trusts make sense only in the cases where, for example, jurisdiction are established on the same or similar rules and not just on some exorbitant rules, and also in terms of the application of the same applicable law, not same material law, but the same applicable law with uniform connecting factors. And we can see how much problems that may cause, for example, also on European Certificate of Succession, which, for example, is issued by the application of foreign law and foreign rules that do not comply, and they are not in line with the rules of VCR, and some member states may refuse to apply such a succession regulation, and vice versa. It can also happen in the scenarios where such a certificate issued in one member state have to produce effect in third states, and third state is bound by a bilateral treaty and therefore does not recognize the effects of such a certificate. And also, as you already mentioned, colleague Iveta, I think the most important and significant case is TNT Express with regard to the application of 351, but now it specifically dealt with the judicial cooperation in civil and commercial matters. And there was a question whether the rule of Convention of International Carriage of Goods can be applied instead of rule of Brussels regulation if their scope of application coincide or overlap. And the court explicitly said that such rules in private international law instruments cannot have a purpose that conflict the general framework of and the structure of the instrument, and therefore it can only be applied to the extent that it does not compromise the principles of an internal market and also the principles and rules of such an instrument of private international law that it, by its application, want to produce within the internal market. Also, we can also say this is my interesting point of view because, of course, I consider myself really young PL scholar. I'm really humble. I don't want to sound, yeah, but that's how I am. That's my personality. But I'm really attached and I'm really amazed by the writings of Professor Ralph Michaels and also Professor Peter Gesender, because they also have really interesting idea that constitutional law, in particular, at least in European context, emerges as a consequence of private international law solutions. So they see, for example, we can have that, we see numerous cases where primary law of EU trumps private international law. For example, we had that in with regard to the application of country of origin principles. You're maybe aware of case law in Centros, Uberseering, and also Inspire Act, where the member states were basically precluded to apply their own private international law to determine the legal capacity of the corporation, because they were forced to protect their acquired legal capacity under the law of the country of origin, not on the country of destination. And of course, after Centros, there were a lot of refutals to that, specifically regarding the potential circularity of that line of reasoning, because how can we determine what is the legal capacity of a corporation and what law should govern that if we don't apply our own private international law? But that arguments only stand in the cases where we have horizontal and equal application of private international law of different member states, which also raises the problems of comity and sovereignty. But in multi-level governance systems, it's not like that, because principles of private international law have precedence in application. And also regarding to that, there were some professors, specifically Professor Michaels, who put forward a really interesting argument. How can it be that rules of private international law could conflict principles of internal market if they try to ensure proper functioning of the internal market, and therefore, if that's the case, how EU can claim competence under Article 67 and 81. But the thing is resolved by this: such rules does not infringe the general framework of the private international law rules. And also, it's really important to emphasize that from perspective of those member states who are bound by such bilateral treaty with third states, for some of them it would be really lunatic to terminate such treaties, because they would say, okay, that would deteriorate the standards of protection that we already established for our citizens in third countries and otherwise. But of course, we cannot make a stance that those bilateral treaties in abstracto impair proper functioning of the internal market. We need to look to the concrete cases. And okay, I will just mention the last one with regard to the application of foreign law, which is taking into consideration the foreign law which is not applicable by the forum. We just need to think not in terms of the duty that stems from the foreign law, but it's by itself, but just to look at this situation through the analytical process of member states court they do. For example, in the mind of the conflict of lawyer, when we see a cross-border element, a cross-border situation, for us it will be really natural to see, okay, if that's law, this law should be applicable by the virtue of the application of that law from one jurisdiction or the other. We would tend to see for the outcomes. Of course, those outcomes would not determine our own realization and position how to approach this case. Of course, we will look first for the rules of jurisdiction of our own courts and etc. But that does not make any particular theoretical problems in my case. So if we make a statement that that there is a duty of member states not bound by said treaty, if that holds true, I just came up with two possible proposals to that situation: how to correct the concurrent application of bilateral treaties and ESR rules across the member states in order to not impair and infringe principles of proper function of internal market. So first one is of course, application of the adaptation method. So yeah, as for those who don't know, adaptation method can be considered as a methodological tool by which we ignore or modify certain conflict of law rules or substantive rules in order to produce a justified result that each of the involved countries separately wants to achieve. And the other is the application of the appropriate rules of ECR depending on the constellation of facts and activities of the parties. So here we will have certain hypothetical. Okay, I will be quick. Okay, then this one requires a lot of talk. Okay, maybe we can just jump to this one. Those who are interested, I can maybe forward you. So this is the same situation as in OP case. So person who was a national of third state, having habitual residency in member state A, bound by a bilateral treaty with that third state, and owning the boomable asset located in member state A and the member state B, wants to draw up a notarial will according to Article 22, which contains a provision choosing the law of the third state as his lex nationalis, and to rule on a succession as a whole. Notary member state A would of course apply conflict of law rules of bilateral treaty because it's his imperative norm, positive law, and would refuse to draw up such a notarial will. And but if that person, and this is potential forum shopping as well, decides to go to the other member states which are not bound by such a treaty, it could easily conclude such a contract, draw up such a notarial will. So this would of course involve problems of the enforcement in member state A regarding those immovable assets that are located there, and from the perspective of member state A, such notarial will is of course null and void. So let's see how this potential problem could be approached. So, as you may realize, question is whether notaries in member state B may be precluded to apply Article 22 after taking into consideration the bilateral treaty enforced between member state A and third state. Since limited choice of law, as we already told, represents an exemption from General Rule Article 21, it cannot be conceived as an underlying principle of ESR. And that was also the conclusion of the court and the Attorney General in particular OP case. So that, of course, further implies that if notaries of member state B drew up a notarial will with designation of a choice of law, but the deceased choosing his lex nationalis, it would not be applied in member state. It would not be recognized and enforced in member state A because they could claim that it violates in their own public policy and their obligation towards that third state stemming from the international law agreement. So. How can we probably resolve this issue by taking into consideration those rules and maybe applying adaptation in certain case? So courts in order to comply with Article 351.2, notaries of member state B might be inclined to decline its jurisdiction to draw up such a will. However, such extensive interpretation, in my view, would be contra legem, because if the adaptation is carried out in proposed manner, notaries of member state B would discriminate against the national of third states on the ground of nationality, which is forbidden under Article 80, and because in the same case, if national member state A wishes to do the same, courts of member state A will permit it. So no constitutional justification could be found for such a different treatment in the present case. So this is the situation that Professor Dannemann described, where adaptation could create accidental discrimination. So no adaptation can occur in this case. So yeah, that would be it for me today. Thank you very much. I consider this really successful, not just today, but also the yesterday. And I'm really grateful for your contribution, because I think that my mind really changed and my perspective really changed. Especially, I don't want to discriminate, but when I listen to Professor Slavko, to Professor Solomon, when they speak about some things, I'm really amazed, and it really motivates me. It's a really humbling experience, and I'm really looking forward also for other occasions where we will meet and speak. Thank you very much.